Welcome to the Judicial Proceedings Committee. We've got a couple vote lists. We're going to start off with vote list number 24, which are Senate bills. Right? Can we do that? Yep. All right.
And some House bills.
And a couple House bills, yeah. So, all right. Do you all remember? So, this is for Senator Huff and Senator Castley in particular, but Senate Bill 289, the Anne Arundel marriage.
Yes.
You just as long as you report that back, I'm saying.
Yeah.
All right.
He didn't ask me.
Let's.
The sponsor asked me.
Okay. All right.
Heather to explain it to everyone.
Yeah. So let's have. Hold on 1 second. We're gonna let council's gonna bring it up, and we'll discuss it for a second, and then we'll see what the committee wants to do with it.
There are 2 minutes for it. There's 24. So it lets me scan a number of documents, but I can't.
Which one?
The one that we didn't even know that there was a soft spot.
Our cameras aren't working if you want to make an announcement as well.
Okay, so I'm being told by OIS that our cameras are not working, so you'll just hear the audio debate. So when members speak, we'll just make sure that we'll hold the debate before we go. Just make sure you're speaking into your microphone and your microphone's lit consistently before you talk. All right. So Senator Cap.
This bill only applies to Anne Arundel County. This bill authorizes alternate proceedings or procedures for obtaining a marriage license and performing marriage ceremonies in Anne Arundel County by codifying procedures that were initially implemented statewide in accordance with the executive order issued during the pandemic. The bill establishes that in Anne Arundel County, if a marriage is to be performed within Anne Arundel County, a party to be married may apply for a marriage license by providing a clerk a marriage license application by mail, courthouse, drop box, or by email, and include the application payment to the clerk. The information submitted in the application may be sworn under oath before the clerk via video conferencing, or if the use of video conferencing is not practicable under the circumstances, the affidavit included by an affidavit included in the application. And then as for performing of the marriage ceremony, the application, then the parties to be married, but everybody, the parties to be married, the person performing the ceremony must all be in Anne Arundel County, and the parties to be married must be in the same physical location. There are two amendments. I'm having technical difficulties emailing you the amendments out. If you'd like for me to print copies, I can do that. One of the amendments is from Senator Riley, which is 773327/1, which would extend the bill to include Frederick County, Washington County, and Wacomico County, in addition to Anne Arundel County. And then there is the Second Amendment by Senator Rosapep, which is 133229/1. This would extend the bill's application to also include Baltimore County and Prince George's County, and then also provide for a delayed, potentially the delayed effect of submitting an online application for a marriage license and procedures to implement that. However, that would only be done if the Judicial Information Systems determines that information systems are sufficient to support an online processing of marriage licenses.
Okay. So we have Senator Pop, Senator Hellman, Senator Bailey.
Yeah, I don't know why there's an amendment for our Frederick County in there, because our delegation never got brought up to this, and this is news to me. So, A, I don't like the bill, and I think myself and others have relayed that back to Senator Riley, that we didn't care for the bill. So I don't know why it's being expanded to our regions. Maybe that's his punishment for not liking the bill. But
You know who asked me to put it on?
yeah, well, so I think Senator Casserly laid out last time the summary of my concerns about going all virtual to these wedding ceremonies, especially with the testimony we've had in the bill, or in the past, about fear of coerced marriages and things like that. I just think it's, during COVID, a good practice, but I fear during real times. And just to be consistent, Senator West had a similar bill that we had issues. We did amendments and fixed it, but I don't know there's a fix for this, so I would rather just move unfavorable on it.
So the motion's been seconded, but let's have the discussion still open. Senator Hedelman and then Bailey.
Thank you, Mr. Chairman. I'm actually going to echo my colleague's remarks. I'm sort of astounded that Baltimore County was put in there, because this is the first I'm hearing of it. And my first question was going to be, is this a local bill? I mean, has the Anne Arundel County delegation sent a letter? And if it was, I was like, okay, maybe, but
I'm just a guy that gets amendments. I don't know. I have no idea where those amendments came from. Where did they come from? Where did those two amendments come from?
I think the sponsor, right?
From the sponsors of the amendments.
Oh,
One
wow,
was Senator
okay.
Rosapep, the other was Senator Riley.
Right.
Got it.
There is the
Okay.
delegation letter from the delegation.
From which delegation?
The Anne Arundel County delegation.
Yes, but not from Baltimore or Frederick.
Correct.
Got it. Okay.
Okay, I was going to ask. So it seems to have started as a local bill, but obviously now has gone far beyond that. So, yeah, I don't want Baltimore County included without our input. So that's where I am. Thank you.
So I guess that was my question. If this was just an Anne Arundel County bill and it had gone 5-0 in their issue, I would say that just for Anne Arundel County, we should give them the courtesy of a local bill. But with the other counties, I don't think, obviously people represent their counties and don't agree with that, which would be in support of that. But I think for Anne Arundel County, we could look at it that way.
Well, just to be clear, as it's not amended yet, so it only now the bill only pertains to Anne Arundel, right? And so we have not adopted those other amendments. Just to be clear. But so Senator Bailey.
So right now, we're without the amendments?
So some things are really capable of being local bills. I mean, your local property taxes, your local schools issues, local bars, alcohol sales, which truly do affect the local community. But this state has firsthand experience in calling something dealing with marriage a local bill, and that comes from Elkton. Anybody can get married in Anne Arundel County. You have to live in there. All you got to do is say, we're going to have the ceremony in Anne Arundel County. So that means people from all over the state, anybody can say, tomorrow I'm getting married in Anne Arundel County. So, because I want one of these kind of marriages. So it's not truly, looking back in history, Elkton, you can watch all the old movies from the 30s and 40s. People from New York, New Jersey were coming to Elkton to get married because Elkton made a real nice living at this. They had one-stop blood shop, everything was, within 1 hour you could be married, no waiting periods or anything. They were the most liberal marrying jurisdiction in the country up until Las Vegas took over. And so to pretend that, this would be a local bill, no, you're the kids next door, the guy around the corner, the gal downstairs, any of them would be under this jurisdiction. So to the extent that we end up with forced marriages, drunk marriages, coerced marriages, they're not limited to Anne Arundel County. They'd be from all of our jurisdictions. And all you got to do is say that you were in Anne Arundel County when the wedding took place. So you don't have to come to the clerk's office for them to look at you. There's no clerk looking to say, Susie, are you sure you want to do this? Why do you look so worried like that? That doesn't happen. They're on a video screen somewhere. And then when the marriage takes place, the person doing the marriage can be anywhere. It's just that the people being married somehow, which is not clear in this bill, have to be in Anne Arundel County. I don't know if they have to stand in front of the courthouse so you can see they're in Anne Arundel County, but it seems like they could pretty much be anywhere because who's going to prove they weren't in Anne Arundel County, right? They got a marriage license. The person who usually proves you're there is the person doing the ceremony. That's who usually is authorized to say, yes, the wedding took place in Anne Arundel County. So it's, in my view, to call this a local bill, it denigrates the concept of local bills. So I think it's not a good bill for any jurisdiction, and I don't want to let Anne Arundel County pretend that it's a local bill. Thank you.
I basically agree. I certainly don't want it to extend to Baltimore County. Our delegation never considered the bill. I don't know why Senator Rosa Pepe would have introduced an amendment to add Baltimore County to the list. Doesn't make any sense to me. And I think Senator Cassidy made some pretty good arguments about how this sort of thing just can't be limited to Anne Arundel County when you're doing it on screen. So I agree.
This is a roll call. It's a motion that's been made on the unfavorable.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Signor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes.
All right, got a vote.
Bill is unfavorable.
Oh, man. All right. Let's go to Senate Bill 888. You may remember this testimony. Is that Josh?
This bill authorizes the placement of a speed monitoring system, multiple speed monitoring systems in Anne Arundel County on Maryland Route 175, which is Jessup Road, between the Route 175 and 295 interchange and the Anne Arundel County Howard County line, subject to the existing signage and placement requirements for speed cameras. We have received a delegation letter in support of this bill.
Why don't we just get rid of the speed camera law? Because every session now we get a bill for people to put in where they want speed cameras. Made the law restrictive where you could put them. And now every single session we get different bills. I need a speed camera here. I need a speed camera there. So why don't we just get rid of the whole speed camera law and let locals put them wherever we want it? The whole idea that we made it very restrictive is because people were worried that they were going to be turned into a cash cow, and you're going to set these up everywhere and just, basically use them as another tax on motorists. And so that's my fear of these. So, I mean, we can keep voting them out. I'm not voting for them. But this is wrong because we have a whole speed camera system, And every year now, jurisdictions are going to come in, and they're going to continue to try to break out of it. And it gets at the whole criticism of this program in the first place, that it's going to turn into a giant money-making operation and a new tax on motorists. So no.
Yeah, I'm certainly sensitive to that argument. However, and especially living in Montgomery County, believe me. But do you remember the testimony on this one? Where the gentleman's house was, several cars had careened off of the highway and gone right into the backyard, and in some cases you crash into the guy's garage, and some place close to where his children were playing. So there is like a legitimate public safety thing here. It's not just a kind of a monetary. Yeah.
I agree. I remember that, and I remember the photographs, or I don't know if they showed us a video or something. I remember seeing image. So maybe that's a bill to introduce next year. But I think in these very specific, very tailored instances, I think it's fine. So I would move favorable.
Thank you, Mr. Chairman. I remember the testimony, and I mentioned to the sponsor of the bill that it looked familiar to the Route 210 bill. State highways typically don't have these cameras on them because Route 210, the guys were drag racing and had a few fatalities. What we did on I'm supporting the bill. I'm going to vote for the bill. But one of the things we've done in Prince George is because of the number of state highways or state roads that go through Prince George's County that's used by a lot of the folks in Southern Maryland to get to Prince George's, Montgomery, or the metropolitan area, or north. As we put in a bill this year, we kind of combined the bills within Prince George's to also put in a piece of legislation to allow local government to enable local government to place these devices on state roads within the jurisdiction. That's just a note for my colleague from Frederick County.
Let's roll it. See how it goes.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castle.
No.
Senator Hedelman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
Bill is favorable.
So Jamie, we're going to do 5. Look at Senate Bill 515.
Senate Bill 515 is an emergency bill that repeals current provision of law authorizing a student who is a registered sex offender to, under certain circumstances, enter onto real property that is, one, used for public or non-public elementary or secondary education, or two, on which a registered family child care home, a licensed child care home, or a child care institution, or a home used for informal child care is located. Under the bill, each county board of education must develop and adopt a policy that enables a registered sex offender who is a student to continue receiving an education by participating in the home and hospital teaching program for students, or by attending a regional institute for children and adolescents. The State Board of Education must develop and adopt guidelines and a model policy to assist a county board with the development of a policy. I handed out an amendment earlier. I'd actually like to direct the committee to the House amendments for the House cross file. It's House Bill 48. And the House amendments are very similar to the amendments that I passed out from the sponsor earlier. but the House amendments are a little bit broader than the other amendments. It provides that, this is just reading from the House bill, a registrant who is a student shall continue receiving an education in accordance with state law in any of the following locations. One, a location other than real property that is used for public or non-public elementary or secondary education, including by participating in the home and hospital teaching program or participating in a program approved by a county board under paragraph 2. Or in a regional institute for children and adolescents. That's a little bit distinguishable from the amendment that you have at your desks. The amendment that was passed out just added attending a non-public education program to the list that's there, so it would be a non-public school as provided for in the education article. So there's definitely a difference between the two amendments, or the two versions.
Thank you. Okay.
I'm sorry, did you say you did give us a House amendment or not? I didn't. You didn't, okay. Because I got 2 copies of the Senate amendment, and none of them, okay.
Accessible on your laptop, Senator. House Bill, it's House Bill 48.
Thanks, Mr. Chair. I'm not really 1,000% sure. I don't remember the testimony on the bill in particular for some reason, but because the fiscal note doesn't have a state fiscal effect, and it says it could be a substantial financial burden on the local jurisdictions, my first concern is we don't know really what that is. And I guess I'm concerned that I'm thinking, one, this could encompass a lot of children or a little bit of children. If it's a lot of children, if it includes our favorite subject, 4th degree, which is like offensive touching, which is a relatively lower level offense, and then with those children would be then relegated under this bill to be extricated from regular public school programs?
So if if it was if the individual was a registrant under the sex offender statute, they would not be able to enter onto the public school property. They would have to attend or receive their education through one of these alternative programs.
So I know that we have a desire to do whatever we can on these sex offenses, but I'll tell you I have a hesitation on this bill. First of all, in the practical reality, because sexual offender registry is there, so many cases there's guilty pleas or there's pleas that don't involve the sex offense because people know they're on the sexual offender registry. They'll say, okay, I'll just plead to a regular assault. So often we don't even capture those people. But the second part of it is we're still talking about children in need of education. Seems like it encompasses a lot. Seems like it's about expending a huge amount of resources for an unknown yet quantity of kids. So for all of those reasons, my inclination on the bill is that we're not really, I have a very much an unreadiness to pass this bill because I don't really feel we have enough data, and I feel like there could be a lot of unintended consequences. So for me, it will be a no. I'd move unfavorable.
Didn't? I will make a favorable on that bill. Yeah. You said the favorable? Oh, you got it. That was like one of the most boss moves I've ever seen. All right, just like move on favorable. I gotta go. All right, Senator West.
This bill resulted from an actual situation in Senator Klausmeyer's district, and some of my constituents attend the same school. So I'm just going to read 2 sentences from the internet that I pulled up during Senator Carter's colloquy. It says a 21-year-old convicted sex offender who was attending Parkville High School has been charged again for the alleged rape of another underage girl. The young woman named Kai is the third underage girl to come forward with accusations. So we have this registered sex offender who's 21 years old attending a high school where most kids graduate at the age of 18 and is serially abusing young girls in the high school. So that was the genesis of the bill. And the idea is we need to get that guy out of the high school into a special educational program so he'll continue to get his education, but not in a high school with lots of other girls. I support the bill.
What was let me ask one.
We have to adopt the amendment.
Yeah.
Which amendment?
So you have two sets of amendments before you. Can you re-explain the amendments and then we'll.
Right, so the House version provides that the student would need to get their education in accordance with state law, either at a location other than real property used for public or non-public elementary or secondary education. And the examples of that are, in the House version, participating in the home and hospital teaching program for students, or participating in or attending a program approved by a county board under paragraph 2 of this subsection. So that allows the county to develop that program or approve that program. The second option is that they could attend a regional institute for children and adolescents. So that's the House version. The Senate amendment provides that the registrant would need to continue receiving education in accordance with state law by, there are 3 avenues. So participating in home and hospital, attending a regional institute for children and adolescents, or attending a non-public education program, and that's a program that's provided for under the education article. So it's the House amendment is a little bit broader because it basically says it needs to be someplace other than the public school. And the examples that it provides are home and hospital or another program that's approved by the county. So it basically just says like it needs to be someplace that's not the school, whereas the Senate amendment is more specific and provides 3 avenues, and it can only be the home and hospital, the regional institute for children, or the non-public school.
Senator Hedelman and Senator.
Yeah, I have a question because and I'm very familiar with the situation in my county, but that person was 21 years old, and we're talking about students, and we're talking about students between the ages of 5 and 17, right, who have the requirement to be in public school. So does this even have any applicability to that particular situation?
I believe it's that you're entitled to a public education up to the age of 21.
Up to the age of 21?
Right.
Okay. So it would. Okay, that answers. Thank you.
I think the House amendment sounds a little broader and a little better, so I would move favorably on the House amendment.
Yeah, we'll let her add the vote. So is everyone okay so far? I know she'll add her vote when she comes back. Huh? Well, let's roll it then. Let's do a roll call. Oh, sorry, yes, Senator Sidnor.
Thank you. Just, I thought that Senator Carter had moved unfavorable.
She didn't get a second.
Gotcha.
Yeah,
okay.
She moved favorable and then last.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes. Senator Castle.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes.
I understand. We'll talk later about the problem.
Do you want to go to the House bill then, or just?
Yeah, let's finish the Senate bills and then we'll go back if they're the ones that are cross-filed in the same. Do the consent. All right. We did vitals. Let's go ahead. So Heather, Senate Bill 524.
So under current law, when multiple polluters damage resources, liability is apportioned among the polluters for settlement purposes pro rata. That means that all polluters are responsible for equal shares that are determined by dividing the common liability by the number of joint tortfeasors. So, for example, in a suit against 10 polluters for causing oil pollution, a settlement with one party would reduce the responsibility of the remaining polluters by 10%. That's true regardless of the settling polluter's contribution to the damage. So, under this bill, the bill will alter the effect of multi-defendant pollution cases involving a settlement. So, under the bill, if a person settles with the state, the potential liability of the non-settling persons is reduced by the settling person's percentage of comparable responsibility. If a person settles with the state, all the non-settling persons will remain joint and severally liable. And then to go off of the proposed amendment that I emailed out to you a moment ago, there are further clarifying amendments in here. One of the clarifying amendments is that a settlement will not affect the ability of the department to impose a penalty on any other person responsible for the discharge. And just to clarify again that the settlement does not affect the joint and several liability of a non-settling party. This is Senate Bill 524. What? So some of the concerns that were raised by the opposition had to do with joint and several liability. This makes it clear that joint and several liability is not being taken away. Like it still would apply to the non-settling individuals. It also made a change. Let me clarify. So under the previous version of the bill, a person responsible for the discharge and they have settled, they would have been able, the individual they settled with would have been able to turn around and seek contribution from a party that had not settled yet with the state. And this bill took that away and put it back to current law, which says no, that you cannot seek contribution from a party that has not settled their liability to the state yet. So that was another concern that had been raised. Yes, that's under the amendment. That was another concern that had been raised.
Can we hold this for a little later? Because I need to look at all the amendments and stuff. I think they just got sent out. And this bill had a ton of opposition as it came in.
No, it did. It's a big bill.
Confusing in the hearing.
So there's another thing too. I almost think that we should do almost like a diet.
You got to send them to our laptop.
Did it?
Yeah, that's right. Actually, yeah, I should say make that announcement. The amendments and everything should be sent to our laptops, just because.
So I need you to send me what
Yes, got
emails
it.
you want, because I'm just sending them to the standard email that I have access to.
So it's probably best practice. We'll make sure to do that for the
So
beginning of
if you
next
could
session as well.
email me
But,
what
yeah.
email that you'd like it to be sent to.
Got it. But in the meantime, maybe even if we have to delay this longer, it's just senator dot, first initial, and you'll see laptop in parentheses.
It doesn't. Yeah, it won't come up on ours, so we don't know what they. It is.
We'll get them for you guys. You almost need a diagram, Heather, to explain. Maybe we can work on one if we have to hold this again, just to show like how the litigation would work. Okay. Okay, Senator Castley.
I never got answered in this bill, which was a good point made by some of the opposition. Was it on page 3 of the bill at lines 24 or 26? It says a fact finder shall make certain findings, but we only have a fact finder if there's a trial. This talks about settlement and responsibilities under settlement when there would never actually be a fact finder. And so then we end up with people at trial who we got people settling who who supposedly don't know what their liability, their share of the liability is, and other people going to trial without knowing what the other people have already settled for. It seems like a very difficult kind of I just don't know how you can assign comparative responsibility to all the parties joined in legal action, so I'm going into a case, and I'm one of those parties that didn't settle. I mean, maybe the fact finder, I don't know who this fact finder is and how they assign, but if they say, oh, you're only responsible for 0.0001%, I'm like, well, what the heck am I going to trial for? But I'm not going to know that based upon these other settlements. So I don't know if that was resolved in an amendment or something. It just seems like a really strong issue for how this bill is supposed to work.
So the concern that you raise is not addressed under these amendments. The area that you referred to, that was struck from the bill under the amendments. So on page 3, page 3, lines 21 through 23 are struck. However, if you turn to page 4 of the bill, it altered paragraph 3 on line 17. And so it adds the fact finder language back into the bill, beginning on, I'll just read the whole paragraph. A settlement that resolves the liability of a particular person responsible for the discharge reduces the potential joint and several liability of other persons responsible for the discharge by the settling person's percentage of comparative responsibility, and then as assigned by the fact finder for all settled claims, including all statutory and common law claims. So you're concerned about the fact finder language and determining the percentage of comparative responsibility is still in the amendment.
That's in the amendment.
That's in the amendment.
Thank you.
Thank you, Mr. Chair. This area of law is one of the most confusing areas in the entire legal system. I got involved in it as a very young lawyer, and I nearly lost my religion trying to figure what was going on. Each state, time was when each state had their own joint tortfeasor act, and they were all inconsistent. And then eventually, a recommended uniform national joint tortfeasor act was put together by the uniform law commissioners, and most states, including Maryland, adopted it. There is a huge body of law interpreting the Uniform Tortfeasor Act. This bill would take Maryland out of the Uniform Act and make Maryland's law ununiform. It is a serious decision for us to make, and I don't think we've done enough research or discussion to make that issue on the fly in the last 2 weeks of the session. My thought is this would be a classic case where this bill would be appropriate for a summer study, including some of the state's top lawyers, both on the plaintiffs and the defense side, and other stakeholders, critical stakeholders.
Senator Cassidy, you want to go back?
No, I'm sorry.
Okay, good. Senator Bailey.
So I guess this would be for council on this bill, and I remember when we discussed it, there was some confusion, at least to me, about the fact that if a person or a company had done a cleanup of an actual site, and they had cleaned that site up, gone along with the Maryland Department of the Environment's rules and regulations at the time, cleaned it up, now all of a sudden, 20 years later, they could now be again held liable for what they had done, and if they even cleaned it up to the standards established by the Department of the Environment at that time. Is that true?
I don't believe this bill's dealing with that. It has to do with an unresolved case. So if the bill has to do with the proportioning of liability. So if a party had already entered into an agreement or had settled with the state or had resolved the claim, I do not believe this bill would be interpreted to undo a previous agreement.
So my question is, if a property, I hold a property and we have an accident on that property, and now that property is sold, there is now a new person that is there, and a new, and potentially new victim, even though everything was cleaned up at that initially to the time, because now the way that we clean up environmental accidents are completely different than the way that it happened 25 or 30 years ago. And my question is, if that happens through the fact that now you have new people that are there, they're involved in that property, are they then liable, or could they go back to the initial people that had been involved with the tanks, with any underground issue, and then hold them responsible for this?
So again, the changes that are being made in this bill, it affects proportions of liability and how you distribute the liability of non-settling individuals, and not who those individuals are. This bill's not changing at all who the defendants are, just the liability proportioning.
Okay.
There's still jointly and several liability, but it's the effects of a settlement agreement that's being changed.
Thank you, Mr. Chair. I just want to make 2 points. One, it was mentioned, the Maryland Uniform Contribution Among Joint Tortfeasors Act was mentioned earlier, but I would point this committee's attention to page 2 of our Attorney General's testimony, which reads, it would not amend the UCATA, which appears in the court article. Instead, it creates a way to fairly apportion responsibility in the largest and most complex environmental pollution cases that we handle, hazardous substance and oil pollution. The bill accomplishes that by removing the UCATA reference from Title VII and applying the same fair apportionment language equally in Titles 7 and 4. The legislation thus is focused on the industry-wide pollution claims that the state brings in parents portray capacity on behalf of all Marylanders. It does not alter UCATA, which will continue to apply to all other tort suits. So that was one thing that I just wanted to put out for the body. Secondly, I believe comparative negligence and proportionate and using this type of bill to proportion out liability makes sense, I think. But if we were to move and talk about any type of summer study, I think the state needs to go and continue looking back at contributory negligence and comparative negligence. So that's all I wanted to say.
Thank you, Senator. I'm glad you actually brought the letter up, because Mr. Kemmerer's, or the Attorney General's letter, also does a good job of explaining the amendments as well. So it's probably like an easier way to digest what the amendments do. Senator Casserly.
Chairman. So I'm looking at the reprint. Thank you, Counsel. I got that. And then on page 4, in lines 7 through 11. And what it says is, if a person responsible for the discharge resolves the person's liability to the state in a settlement, the person shall not be liable for claims for non-contractual or contribution or indemnity regarding any manner or claim addressed in the settlement, including any statutory or common law claim. So I'm troubled by that because we're distinguishing between, so if my rights vis-a-vis someone else were established by statute or common law, those go away, and the only one that remains is one by contract. And I mean, contractual claim, the contract kind of favors the big rich guy who has lots of lawyers to put in contractual protections. But if I'm doing business, if I'm carrying on my life and it says, here's the law, why should I be able to rely upon the law? Why do I need to do a contract? It's like saying, well, I need to do a contract to make sure that you don't drive across my property. Well, the law says you can't drive across my property, so I'm not going to do a separate contract with you not to drive across my property because you already can't do it. But if you were to tell me, well, someday we might just rescind that law on driving across somebody's property, and then so you better do a contract with people to tell everybody don't drive across your property in case we ever rescind the law on this. I'm not understanding a provision like that because some people are protected by contract, some people are protected by statute, some people are protected by common law. But I see all of those as they all weigh equally in my mind. If I was rich enough and powerful enough to secure all my rights by contract, good for you. That's wonderful. But if you weren't and you just relied upon what most of us rely upon, which is the statutes and common law to protect your rights, somehow you're disadvantaged. So I'm not understanding why we're differentiating there, and I don't want to just reward big wealthy folks who get lots of lawyers and put every damn thing on a contract. So that's the challenge I have with this. Thank you.
All right, we're going to hold the bill for a little bit, and we'll move on to let's pull up the list. Sorry, which one was it? Lamb. Senate Bill 46. And we are in possession of the House cross file, is that right? We are. So the House, counsel will let us know.
The House cross-file to Senate Bill 46 is House Bill 231. So Senate Bill 46 prohibits the discovery or perception of or belief about another person's race, color, national origin, sex, gender identity, or sexual orientation, whether or not accurate, as legally adequate provocation to mitigate murder or manslaughter or assault in the first degree to assault in the second degree or another lesser offense. So it just in short prohibits the discovery or perception of any of those things or belief about any of those things from being used to mitigate murder to manslaughter or assault to a lesser degree or a lesser offense. The House amendments, which is House Bill 231, changed the bill as it applied to the assault mitigation and it provides that the discovery or perception of or belief about another person's race, color, national origin, sex, gender identity, or sexual orientation, whether or not accurate, is not a defense to the crime of assault in any degree. So that would seem to be broader than that it couldn't mitigate.
We heard this like the first week or two we started hearings. And my memory on this, I don't know if Senator Castley remembers too, I thought there was narrow case law that they were trying to use similar to this that didn't seem to make sense. I thought there was case law with husbands or wives, or I'm trying to remember the hearing on this because it was But I thought there was a case law they were trying to use that was much more narrow than this as far as the exception, or am I thinking of a different bill?
Senator, that prohibits something along those lines. Let me just pull up the statute for you. It's in the criminal law article.
I'm sorry, I think this was literally our first week of hearings this came up.
The current law provides the discovery of one's spouse engaged in sexual intercourse with another does not constitute legally adequate provocation for the purpose of mitigating a killing from the crime of murder to voluntary manslaughter, even though the killing was provoked by the discovery.
So if you look at the fiscal note, it just says like the current law. It's got the Tripp State v. State and the Jones v. State. I think that's what you're referring to.
Yeah, and I remember when I was questioning him, there was a problem, and forgive me because it's been, like I said, I think this was months ago that we dealt with this. That my memory of it was that was very narrowly construed, and the problem with this legally was that this was a very broad construction. I mean, maybe ask the council. I don't know who, but I mean, that was my memory of this bill, or at least the legal problem with it.
I'm sorry, Senator, what was the question?
My memory of this, and there was a problem that came up in the hearing legally about it, in that I thought the issue was that it was a very narrow construct the way it is in current law, and that this made it very broad, like a broad exception versus a narrow one as it currently extends.
Well, I mean, if I'm understanding you right, I think the reference that you and the chairman had made to Tripp versus State provides that to reduce homicide to manslaughter, there must not simply be provocation and psychosocial fact, but one of certain fairly well-defined classes of provocation recognized as being adequate as a matter of law. Is that along the lines of what you were asking?
Yeah, I got to look at this Tripp versus State, because I remember I asked them about this during the hearing, and it didn't add up to the elements that they were talking about. This it didn't add up to Tripp versus State. I'm trying to remember.
I mean, the crux of the bill really gets down to I'm looking at the reprint on the House side. I mean, it really gets down to whether, there's a lot of other words in there, but what it really comes down to in modern society is, if you climb into bed with somebody believing they're one sex, and you spend some appreciable amount of time there, and at some point in all of this, you suddenly realize that after having engaged in a lot of other activities, you suddenly realize you are not the sex that I thought I was getting in bed with, and under this, your only recourse is to say, oh, sorry about that, I thought you were something else, and get up and walk away. And if you slapped them, struck them, threatened them, said anything harsh to them, you would be guilty of assault. That your only proper recourse under this bill would be to say, okay, obviously, the fact that you lied to me and misled me is really of no big import. I'll just have a good day and you walk away. If that's human nature and that's what the conduct what we want to, if that's how we want to say people are supposed to act, then we should pass this bill.
Yeah, I think this bill has some relevance with what's going on with the anti-Asian American violence right now. They're panicked. They should not be able to use this defense to justify beating up or murdering a person because of the fear, because of this person's ethnicity or is this American of Asian descent. So I see some relevance here too. So I think this is a good bill. And I think a lot of attacks now are against the LGBTQ community right now, and I think they're really being attacked, and I could see this is a good bill. Anyway.
Thank you. And Senator Lee actually touched on the question that I had, and I remember when they were testifying about this bill, and I forget who, but I believe I had raised the question about why it was broadened from this year as opposed to last year, where we focused on the LGBTQ community, and where I think the issue that this bill is attempting to address. I think last year it focused on that community, broadened this year. The movie that I was attempting to recollect was Imitation of Life. And in that movie, you had a very light-skinned black woman who was passing for white. And when her mother came, and I guess her suitor or realized that she was actually a black woman, he beat her. With that said, I still don't know why this bill is as broad as it is when I don't think that, the whole idea of discovering that someone may be a race that you don't think that they are, or color, I just don't think that that's been an issue. I do think when it comes to gender identity and sexual orientation, that's where the issue lies. So I just put that out there. I'm not saying I would not vote for this bill because of that, but that's just something that I wanted to raise.
So are you trying to draw the distinction between like the immutable, or what were you, Hugh?
No, not. Again, I go back to last year's bill. I don't think last year's bill included a race, color, national origin. It may have been sex, gender identity, and sexual orientation, but it was limited. I would suggest that those are where the issues have been, and I think that was really, when you look at the testimony from that day, that's what people were testifying. They weren't testifying about these other categories.
Or more now. So the bill says that you cannot use that as a defense, correct? Well, now my memory is on the Tripp decision, that is a very narrow case. The only time I think that we say you can't use that as a defense is crime of passion, or you found out they were cheating. Isn't that what it is? It's found out you as an affair and as a passion? Okay, that is the only time in law that we allow that say you can't use that as a defense. But generally speaking, we allow people to use all kinds of stupid, illogical things as defenses. That doesn't mean it's going to work, but we don't generally limit what people would use as a defense in cases, except for this one very narrow exception. And so I throw that out there for people in the committee who are generally, let's say the committee's more defense-oriented than I am generally, and so it is, we are getting into the business now of limiting what people can use as a defense in court, and that's, people can walk in and say all kinds of stupid things as defenses. It doesn't mean a judge or jury is going to buy it. And to take what is under law now a narrow construction of a defense and to broaden it out, I would think for the people who are defense-oriented, they would be a little worried about starting down the road of having the General Assembly limit what people can use as defenses. It doesn't mean they're going to get out. I don't think a defense in a lot of these cases would necessarily be of help, but it is a good question for us if we want to be in that business of limiting what people can do as defense. This is not a very defense-oriented bill. Looking at it, state's attorneys like it. They would like to greatly limit what people can use as defenses and what they can say.
I understand the intent of the bill. I actually think if we're going to pass it, it's probably better in the broader form. But I actually do have some concern for two reasons. One, we're talking about limiting a defense, but we don't address anything about the way the charges are brought to begin with. And I think that there's a greater likelihood that the charges would be brought in a different way because of the bias or racism within the prosecutor, or the prosecutor believing because this person was a transgender, I probably can't get murder, so I'm not going to charge it. I really think the bulk of the problem lies in that body, much less so in the defense part. I also would like to know, was there a specific case where this was successfully used? Because I can't, like Senator Huff said, I can't really imagine it being used as a defense and being a successful defense, that, you know, I thought the person was white and it turned out that she was black, so I killed her. Because I was so shocked. Or I thought the person was a man or a woman, so I felt justified in killing her. So that's what I wanted to know. I get the intent. I understand the intent, but I don't know. Was there ever a case where it was successfully used? Was that testified to?
I don't recall, Senator, from the testimony. I'd have to look into it, but I don't recall.
Thank you, Mr. Chairman. I was just looking at Free State Justice's testimony, and they do have some cases there that they cite where it has been used as a defense. I don't, well, one time in Germantown, Maryland in 2000. To bring down the charge for second degree instead of first degree murder.
With all due respect on that, if you say I went in there, we were having relations or whatever, and then I found this out and I killed them, that is a second degree murder. That's not a first degree. You didn't walk in there premeditated planning to kill someone. So in that way, it's not necessarily a defense, but I guess a mitigation in that you're showing there wasn't predetermination.
Well, that's what the bill's trying to get.
The bill does, that's the bill does, though.
Oh, but I mean, well, then that's a problem, because if you look, murder is obviously wrong in all cases, and that's why, of course, maybe they want second degree murder now, because they'll serve less time under our sentences structure than first. But I won't get into that. That is an issue, though, because under second degree or first degree, you have to prove that it was premeditated. And if you're taking away somebody's defense to prove whether it's premeditated or not, I mean, that's where I get into, look, nobody's justifying any of this stuff. It's all bad, but we do have to have scales of balance, and I get worried about taking away somebody's ability of defense to prove if something was premeditated or not.
So, Mr. Chairman, I would just urge you to look at the testimony, because they do go through, if you scroll down, they cite 4 cases in Maryland where this has been used. So if we want to look to real experience, I think it'd be important to look at this testimony.
Was there an amendment in the House version?
It's
Would that help in this?
well, the House version provided that those factors couldn't be used as a defense to assault in any degree. So I believe how it's drafted as it came in said that it couldn't be used to mitigate to a lesser degree of assault. But the way that the House amended it said that race, color, national origin, sex, gender identity, or sexual orientation, whether or not accurate, is not a defense to the crime of assault in any degree or discovery of any of those things.
Sure. I mean, there's the 2 parts of the bill, and I think you have to look at each one. One has to do with mitigation in the case of a killing, and the other would be assault. And looking at the one on killing, it's copied from the B right above that, which deals with finding one spouse engaged in sexual intercourse, and it says you can't mitigate from murder to manslaughter, to voluntary manslaughter. Jimmy, is there a difference between voluntary manslaughter and manslaughter? It's the same.
Voluntary manslaughter is a species of manslaughter overall, because there'd be involuntary manslaughter.
Oh, okay. All right, yeah. So you couldn't mitigate from murder to voluntary manslaughter, and this section C just says the same, that you couldn't justify killing somebody for discovering. I mean, I agree with Senator Sidnor. I mean, I think the only one that you've been in bed with somebody, presumably you've discovered everything except perhaps their gender. I mean, most of the other stuff, presumably you would have known at some point. And then, so then it's killing doesn't allow you to, I mean, you wouldn't, if it was like sudden and impassioned, so there's no premeditation, so it wouldn't be first degree murder, but it could be murder, and then you couldn't get away with it, it's only manslaughter. So C sort of follows from B above it. The second one, I think, is more problematic because it deals with assault, which is not currently in the statute that I can see for anyone. So if you have somebody who was, who was homosexual, who gets into bed with somebody else believing they're of the same sex that they are, and they go pretty far along and say it's a young woman, and she suddenly realizes the person she's been in bed with for the last hour is a female, who looks like a female, and maybe she's really irate about the fact that she was betrayed and is very angry, and she slaps him. That's an assault. She just assaulted him. So she would have to say, no, you can't even, no smacks. All you have to do is just say, oh, not what I thought, and stand up and walk away very calmly. And even if she stood there and screamed and threatened him, that could be an assault. If she picked up a baseball bat and said, I'm so angry, I'll whack you. That's an assault. I mean, if she smacks him, that's a battery. I don't know. Is that do we want to say that? Is that she could never say, well, that was the reason I did it. It's no, you hit him. So I'm not sure if that's where you want to go with the law. I mean, sure, I'm not in favor of her shooting the guy or gal or whatever. I don't have much problem with C, that people shouldn't be able to kill people for that. But I just don't know if it's reasonable for us to expect that under those circumstances to say, no, you just have to say, okay, listen, I'll see you later. Goodbye.
See, Senator Castley just lost me at the end. I wasn't sure what you just meant. You can say, see you later, bye. I was following you for a minute. So I'm looking at the case law, and I don't want to, what concerns me, I like the intent of the bill. Nothing should be mitigated down to a lesser offense because someone is a racist or a homophobe or whatever. That should never happen. I do have concerns, though, because I'm not certain that posturing this as a defense mitigation is the right thing to do. Is this, so the way this is written, this would simply be included in a jury instruction in a criminal trial where it was a relevant issue?
I imagine it probably would be included in, yeah.
I don't think that's accurate as the bill is written. I think they wouldn't be allowed to offer the defense.
Right.
It wouldn't be in a jury instruction. I don't think the defense would be allowed to be offered in court.
That's a good point. That it couldn't be asserted to begin with because you would be making the defense, and it's just disallowed by statute.
So I think, though, that what Senator Castley is saying might be a little bit of the concern I have, too, which is when we're talking about premeditated murder, first degree, versus heat of passion, second degree, not planned out, but it was a response, a bad one, to something. Now we're getting into the mind to try to ascertain if the heat of, if there was, this bill is saying that if you're a racist, that killing someone in heat of passion is not acceptable heat of passion. Like you can't, we can no longer accept that this was a response for you, unpremeditated, because of race. It just, I don't know. The reason I say that is I'm pretty sure race and all of these other factors are factors in like mostly every case. Like Senator Castley might be more inclined to slap me then he might, Senator
All right,
Hellman, unconsciously might have
Let's not go.
biased
All right, all right.
thing. Or somebody, like, you know what I'm saying? It's so embedded in our psyche, in society. I don't know that we can extract it for this. But that being said, I'm not here to we might actually, don't get mad, but I really would like to put a partial hold because I'd like to read through some of these cases that Senator Hellman pointed out. I'm reading through them, but I'm not sure that even though they conclude that this is the problem, that they really address the issue.
So this unreadiness, can we suggest this, though? Can we adopt the House amendment? Because I think everyone at least agrees that that's a step in the right direction, that we can just hold it. Is that okay with that? So if you look at the reprint, I'll let you explain it, but I don't even know. It just strikes, so on the second page, lines 18 through 19, it strikes those 3 lines. Does not constitute legally adequate provocation to mitigate an assault from the crime of assault in the first degree to assault in the second degree or another lesser crime, and then it just adds in.
It says that it is not a defense to the crime of assault in any degree.
Their amendment expands it or contracts it? Their amendment broadens the bill?
I read that as making it broader because it's saying that it can't be used as a defense at all. There's mitigation, and then there'd be other defenses besides mitigation. So this is saying that it couldn't be used as a defense at all.
Can we just not adopt it? I mean, I'd like to know what we're doing here because, like I said, this is pretty big when we start limiting offenses. It may not on this might not affect a ton of cases. Maybe it does.
Makes it broader. It makes it broader.
My concern, that it's one thing to say, I mean, first degree assault's beating the hell out of them, right? So that's just not, there is no justification for that. But if she finds out and she smacks them, you can't even a smack, even a screaming, threatening, get the hell out, that could still be an assault. So, I mean, say you can't, we're not giving you a license to beat the hell out of them, but if someone reacts and just, even just a smack could be prosecuted. And you're like, wait a second, maybe we could introduce that evidence and say, well, maybe they were emotionally very distraught or something like that. But it seems to me for the most least form of assault, I'm not sure I wouldn't want that to come into evidence. And okay. I mean, now what I see in the Senate version with the first degree, I almost feel more comfortable with the original bill. Because I'm saying, look, you can't be able to kill somebody, and you can't beat the stuffings out of them. But at some point, human nature takes over, and somebody might get angry and smack somebody. And I don't know that we don't want to at least recognize that people may feel betrayed and angry.
I like the broader language, but I understand if people are uncomfortable with that. But all right, what's the pleasure of folks? Senator Carter?
Yes, hold, please.
Okay. All right. All right, Senate Bill 98.
I'm just going to give us an update on Senate Bill 98.
Okay, go ahead.
You want?
Well, I mean, I was going to offer that we just passed the budget, right? And the language dealing with this issue, I assume, was in the budget and was not addressed. Isn't that where we are?
It's in our version of the budget. It's in the
Okay.
Senate version of the budget.
Okay,
It's not in the House. It was,
okay.
yeah. Thank you, Mr. Chairman. Senate Bill 98 is anti-discrimination language applying to private schools. We had a great Zoom on this issue. recently with a number of senators from both parties and advocacy groups on the call. The call went really well, and we came to a consensus on the legislation. I drafted amendments that I believed reflected that consensus to the best of my ability. So I sent those amendments out to the advocacy groups on both sides of the issue. Some advocacy groups supported the amendments. Other advocacy groups had concerns about those amendments. So I've the advocacy groups that had concerns about the amendment as perhaps not reflecting the full compromise that were reached, I sent those concerns to the advocacy groups on the other side, and they're now reviewing those. So I have no reason to think everyone is on the same page here. We don't support discrimination in any form in public schools and private schools, and we just need to be able to find consensus on the right wording there. I think we're close, and we should be hearing back from the advocacy groups soon, and if necessary, we'll pop on another Zoom and get it done. So this is going to happen. We just need a little more time to make this happen.
All right, so I don't, do we have any more Senate bills on the other list, or is they're all? All right, look, I'm going to fight you on this. What do you know, we could drop a calendar of House consent bills as a show of goodwill.
You're on 98.
We've moved on. We are holding that. Yeah, we're transit. So we could drop a consent calendar. If it's the will of the committee to do so, I'll communicate with the chair that we've done so. Are you just going to hold off until Monday?
What's the reason that we're not getting the other way around? That
Say
they're
what?
not dropping a consent calendar.
Look, they're moving two bills right now, and look. We get into these shenanigans every
Only one
year.
is a committee
Look. We get into these shenanigans every year. I promise you, we'll protect our committee product on the other side. But this is how it starts. This is how it starts.
Can I speak up on this?
Sure.
This is not how it starts. So for 3 years, I've been in this situation with the House. They're not all. I'd actually be happy to separate just the judiciary bills. And I'll say, for 3 years we've been in this situation. We have always started moving their stuff first, and it's Lucy pulling the football every single year. And every single year we get in a situation they are not moving our bills. It's been 3 years with the chair and the vice chair over there who do not move JPR bills at the same pace for moving their stuff. And the last couple of years it's only been at the end that we started grinding down or fighting or whatever over it, but we start every year moving their calendars, and I'm just saying this has never worked, moving their calendars, because and it's not just people on our committee. I've got people on other committees. There's one bill here somebody else asked me to hold because they played this game on them last year on it. So there's a lot of games being played over there on it, and I have concerns about starting to move their calendars because it's 3 years of the chair and vice chair over there, and I don't know who's doing what. I have my suspicions, but nonetheless, they don't move our stuff. So it's trust but verify, Mr. Chair, to be honest. I don't want to move all their bills when we've had 3 years of the same thing. In history, why would it all of a sudden they would become good actors and start moving bills?
Senator Sidor. Being on the other side, it's funny to hear this because I recall being in judiciary and looking over here and wondering what in the heck you all were doing with our stuff. So I'll say I'm going to trust our chair and trust their chair and that they'll work it out.
Expressing an extremely unpopular opinion, although I could probably get some support from some of my colleagues here if you think about it. I'd rather spend the time passing our Senate bills that have passed the House already that we need to ensure get out of the Senate rather than the House bills. But that's just me.
All right, we're not going to go back and forth. Senator Hedelman will make a decision here.
No,
Go ahead.
I trust the chair as well, and I think that if it's a limited number and we're showing good faith, then we can always hold further down the line. So.
If you and I trust the chair, is that our chair or their chair?
That's a good distinction there. I appreciate that.
I trust our chair.
All right, look here. Look. We're going to. All right. So I'm going to put together a list of the bills that are in the same posture, the bills that we've passed out that are only judiciary bills. All the bills that are in other committees we'll take up at a later time. I'll put that together. We're coming back on Monday. I'll have some discussions, further discussions, confirmation with the chair over there, the vice chair, and it would be my preference to move some of those House bills as goodwill. In the interim, so look, on Monday, we're going to come back, and we'll have some discussions now, but to Monday, we're going to come back, and we're going to really get into the meat of the police reform conversation, and we're going to have to start making decisions on Monday. So I'm going to have the committee kind of send a rundown of, again, that side-by-side walk, that crosswalk of what was in the House and what was in the Senate, and we can start having that more structured debate on Monday. So just want to be sensitive for folks that have professional responsibilities outside the legislature. What the earliest on Monday? What could work for folks?
Monday we got to come in at noon, right?
Yeah.
So I mean, my Monday's blown up, so I don't care.
Okay.
Why are we coming in at noon?
We're coming. I think it's.
Oh, I thought we had an afternoon session on Monday.
That was last Monday.
We don't have to come in at noon.
Oh, shoot. 7 p.m. Hold on a second. I know. You know what? I think we got executive knowledge or something.
We got it at 5 or something. Is it earlier?
Hold on. I'll take it now. Oh, you know what? Executive knowledge. I don't know. Could we come in like 4 o'clock on executive and knock out our, and then we can hit executive knowledge at 5? How long do you want the vote?
So good. Yeah, that sounds good. Senator Jackson, go ahead.
I've got a delegation meeting at 3, and we have like 15 bills.
So I've got something from 3 to 4. So if we go in at 7, we could go from 4 to 6:30, and then we can have folks can dive in during the day if they have free time. We can have some of those discussions, but you spend the majority of the day working on this. So, all right. So let's do 4 o'clock. 4 o'clock here in committee to do police reform. Sound good? All right, 4 to 6:30. Yeah, I'm going to play hooky from that. Okay.
Well, we got to be there.
That's a big one, yeah.
Day.
Oh, that's at 5. What time
Well,
is
you
that?
want to come in at 3 then? Do you want 2 hours for?
I've got something from 3 to 4.
All right. Well, then I got to do executive knowledge because that's Schrader's in there.
Yeah, I know.
and everything
I
else.
know. We should all be there for that.
Well, then we should do 4. Let's just do an hour then.
And then we can come back.
Yeah, that's fine.
And for the record, before we conclude, I want to say that I trust my chair too. But I'm trying to have all of our backs here as well. So I
got you. I promise you. Yeah. I appreciate that. All right, thanks. All right, so let's do this. So what do we decide? 4 o'clock here. We'll meet for an hour, and then we'll come back. We'll take a little bit of break, and we'll come back before floor. Sound good? All right. All right. See you all later.